Hi, my name is Scott Harn. I'm the editor and publisher of ICMJ's Prospecting and Mining Journal, and appreciate your time to view this presentation by the Minerals and Mining Advisory Council. So this presentation by MAC is titled Restoring Access and Returning to Reasonable Regulation. So what I want to talk to you about today is how did we go from this situation where the miner reports to his mining district for rules and regulations to this situation where the miner has to deal with a local city, county, state, and federal agencies who all want to say in how you run your operation. Well, the answer is that we, the miners, allowed it to happen. Miners, through the use of mining districts, at one time had a seat at the table. So in order to understand how mining districts work, we need to start off with a little bit of history. Back in January of 1848, you had the gold discovery by James Marshall on the American River while constructing Sutter's Mill in California. On February 2nd of 1848, the Treaty of Guadalupe Hidalgo was signed, which ended the Mexican-American War. And about 10 days later, Colonel James B. Mason, he was the commander of the American military forces, signed a decree which stated Mexican laws and customs now prevailing in California are hereby abolished. Well, you still had miners pouring into the area. In June of 1848, there were an estimated 4,000 to 5,000 of them. By the end of 1849, 40,000 miners were estimated in the area. And just 3 years later, an estimated 100,000 miners in the area. So it was up to the miners themselves. They became self-regulating out of necessity, and they are the ones that created order out of chaos. So these mining districts evolved, and rules were set by the miners regarding claim size, marking and staking, the number of claims allowed, forfeiture, and arbitration. Then Congress got into the act, and it was led by a guy by the name of William Stewart. Stewart came out from the New York area to California during the gold rush period to see if he could find his share, and after not having much luck, he decided to go back and finish his law degree. He eventually became a senator for the state of Nevada. He was also instrumental in settling a lot of the cases in the Comstock area for those deposits. So he was the primary author of the Lode Law of 1866, which addressed lode deposits, and the Placer Act of 1870, which was meant to fill the gap after the Lode Law failed to address placer deposits. He was also the primary author of the 1872 Mining Act. And the mining law allows us to explore for minerals and establish rights to federal lands without authorization from any government agency. This provision, known as self-initiation or free access, is the cornerstone of the mining law and still exists today. The 1872 Mining Act stated that under regulations prescribed by law and according to the local customs or rules of miners in the several mining districts, so far as the same are applicable and not inconsistent with the laws of the United States. A few other significant developments along the way. In 1953, California passed a law that forbid the creation of new mining districts, but previously existing districts were grandfathered in. This is one of the primary reasons we ask those who are trying to get their mining districts up and running, if they're not right now, to go back and look and find those original bylaws, if at all possible. It's because of this law, and we are unsure how many other states passed similar laws which prohibited the creation of new mining districts. The 1955 Surface Mining Act stated that any use of the surface of any such mining claim by the United States, its permittees or licensees, shall be such as not to endanger or materially interfere with prospecting, mining, or processing operations or uses reasonably incident thereto. The Minerals Policy Act of 1970. Congress declared it was the continuing policy of the federal government and the national interest to foster and encourage private enterprise in the development of economically sound and stable domestic mining, minerals, metal, and mineral reclamation industries. In 1976, you had FLPMA, the Federal Land Policy and Management Act. This allowed for the establishment of wilderness study areas. But there's a key provision in there, and that states that the public lands be managed in a manner which recognizes the nation's need for domestic sources of minerals, food, timber, and fiber from the public lands, including implementation of the Mining and Minerals Policy Act of 1970. And as you can remember, and it's stated in there, in the national interest to foster and encourage mining. So there's two main reasons that we've lost control. Following World War II, some miners went back to work but allowed their mining district boards to remain vacant. Miners have tried to participate in negotiations that were not true negotiations. The outcome in these situations was already predetermined by those in charge. Here's your first example. In California, the miners participated in public hearings and submitted public comments regarding suction dredging regulations. The California Department of Fish and Wildlife is under no obligation to adhere to those comments, even when they are backed up by scientific research and studies. Fish and Wildlife stated they had new evidence that dredging may be harmful to coho salmon and severe restrictions were being put in place. The agency relied on a single test that was performed in a mercury hotspot and was completed by a member of the U.S. Geological Survey who was also an advisor to the Sierra Club. More legislation was passed requiring dredgers to mitigate all possible harm, which included things like aesthetics and noise, which of course is impossible. Another bill was passed, and that transferred the permitting authority to the State Water Resources Control Board. The Water Board was holding public hearings and asking for comments. Actually, those have already been completed. This board is appointed by Governor Jerry Brown, who made it clear he does not want in-stream mining in California. Board members really have no recourse, either follow Governor Brown's wishes or be out of a job. This is carried over to other states like Oregon and Washington, and we're starting to hear a little bit about this similar stuff in Idaho, where miners are going through the same process and dealing with similar legislation. Second example for you, travel management plans. The U.S. Forest Service continues to issue travel management plans for the various public lands they administer. Public comments and hearings are a component, but the agency continues to ignore the right of ingress and egress for miners and mining operations. The Ninth Circuit Court of Appeals has deferred to the agency to interpret their own rules, which leaves the miner no recourse. So what have we been doing wrong as miners? Well, first, we allowed the mining districts federally recognized entities to fall into disarray, and also participated in negotiations we could not win. So if you don't have a seat at the table, you are on the menu. So how do the miners respond? Because of these unlawful actions by state and federal agencies, we are advising our readers to serve state and federal agents, for example, Fish and Wildlife, Forest Service, and BLM, with what is called a direct and constructive notice until they get their mining districts in order. A direct and constructive notice is the first step in the process to allow an individual to sue a government employee personally for knowingly violating your rights. We published an article explaining how direct and constructive notice works, and that was published in our June 2015 issue. This process was used successfully by Clark Pearson, who sued agents of the Forest Service personally and won. So remember, we still have these tools. We have the Minerals Policy Act of 1970, which says it is the continuing policy of the federal government in the national interest to foster and encourage mining and mineral development on public lands. And the 1872 Mining Act, which includes the wording, according to the local customs or rules of miners in the several mining districts. And I should add in there back the Surface Mining Act of 1955, which states that it is unlawful to materially interfere with a miner. So the mining districts are small geographic areas, some of them less than a few square miles. Each mining district has an elected board made up of claim holders working within this specific geographic area. Each district has their own rules and regulations, though they've always been very similar in nature. Any rules and regulations set will conform with federal law, and each district will seek and obtain a memorandum of understanding with the appropriate federal land management agencies in their area. I'm going to show you this map of mining districts in California. There's actually mining districts located in 21 different states. But virtually anywhere in California where a valuable mineral deposit was found, a mining district was established. So you had 141 of these mining districts by the time California became a state in September of 1850. Over 500 by 1866. So here's a zoomed in section, one of the squares on that map. Coloma is pretty much in the center. That's the location of Sutter's Mill. And this area on this map is approximately 75 by 75 square miles. And just within this area there are 88 mining districts. So why do you need a mining district? Well, mining districts are a legal entity. An organized mining district creates a jurisdictional issue for local, state, and federal agencies. A properly organized mining district can obtain federal recognition. And the needs of small miners have not been met or even addressed in many cases by other groups or associations who claim to be representing you, or the challenges that have been done were done incorrectly. So here's a look at the current structure again. You have the lonely miner trying to deal with local city, county, state, and federal regulators who all want a piece of the action. They all want to say how you can run your operation. So here's the proposed new structure from MAC. The miner would report to his mining district over the standard rules and regulations. The miner would still supply the necessary paperwork, a notice, or a plan of operation as needed to the Bureau of Land Management. The Minerals and Mining Advisory Council was just that, an advisory group who's off to the side to support the miner and the mining district if they have questions, concerns, or something that needs to be arbitrated between the miner and the Bureau of Land Management. You'll notice that all the other agencies are eliminated from this picture. So what is this Minerals and Mining Advisory Council? Well, this is the guy that started this effort. His name is Joe Martori. And he is a placer miner in Southern California in the desert area. He's got a decent size operation with a couple of trommels. And he was getting a little fed up with a lot of the garbage he had to deal with. In the right-hand photo, in the orange shirt, are Joe and his wife and one of his crew members. The blue shirt is Congressman Paul Cook, who's the congressman for that area, and in the white shirt is his wife. Like I mentioned, Joe was fed up by some of the extreme restrictions placed on his operation in Southern California. So he started attending meetings of the Desert Advisory Council, which is a board that makes land use decisions for the desert area that includes his operation. He also reached out to Don Fife, who's a professional geologist and who has served under several previous administrations at the federal and state level. Clark Pearson, who's a legal researcher for public lands for the people. As I mentioned, Congressman Paul Cook, and others for assistance. His mining district, which is the Rand Mining District, board was restaffed following an election held by claim holders in the district. His work paved the way for some educational sessions presented to the Roundtable Committee meeting in Southern California in March of 2016. I did a presentation as well, and mine was on the legal authority of mining districts and the conflicts arising from multiple agencies trying to regulate mining simultaneously. I also mentioned that we have been advising our readers to sue federal agents personally if these agents continue to ignore their rights granted under the mining law. And we provided our readers with instructions on how to do so successfully and highlighted Mr. Pearson's case where he sued and ultimately settled after the Forest Service agreed to transfer a dozen agents out of state. As you can imagine, this got their attention. Other presentations were on the 1955 Multiple Surface Use Act, FLPMA and related laws, the Mineral and Mining Regulatory Reform Act, which is a bill we had proposed, and multiple use lands, symbiotic relations, and conflict resolution. Following our presentations, the Rand Mining District requested a Memorandum of Understanding, an MOU, with the BLM to address many of these issues. The end result was that many of the overlying land designations placed upon the Rand Mining District have been removed and roads and trails have been reopened. This is because those overlying designations were placed without any consultation of the Rand Mining District, and they occurred long after the Rand Mining District was a legal entity that had been formed. Who is MAC? Well, these are your national advisors. Clark Pearson, who I already mentioned, legal researcher. He's also a commercial lode miner with active mines in Northern California. And he has been doing research for public lands for the people for many years. Joe Martori, you saw a photo of him. He's a commercial placer miner and was the founder of MAC. Bill Jensen, a congressional and military advisor. My name's on there too. I was honored to have been asked to be a part of this effort. Donald Fife, the professional geologist and congressional advisor. Chuck Cushman, president of the American Land Rights Association. And Claudia Wise and Joe Green, who are both retired from the Environmental Protection Agency. You're probably asking yourself about now, why the heck will we have a couple people from the EPA on this National Advisory Board for MAC? Well, both Claudia and Joe had been working on a couple different papers, and both came to the conclusion that what dredgers are doing to the environment is less than significant. In fact, in some cases, what they are doing is beneficial for fish, especially the coho salmon and other fish up in Northern California. When they completed these studies and completed their papers, they provided them to the EPA for publishing, but the EPA refused. This conclusions that they had come to were not in line with the EPA's overall views that suction dredging is detrimental. So both of them retired. And since that time, they have become advisors. In fact, they are both actually gold prospectors. So we also have a group of MAC administrators who were elected by miners, chosen by their peers, to assist other miners who wish to get their mining districts organized again if needed. If you're watching this video at one of these mining district meetings, then chances are one of these administrators has been helping out. There are over 40 state MAC administrators across the U.S., and they're located in those states where traditional mining districts were established. Some of these names may surprise you, but the states where mining districts have been established in the past include Alaska, Arizona, Arkansas, California, Colorado, Florida, Idaho, Louisiana, Mississippi, Montana, Nebraska, Nevada, New Mexico, North Dakota and South Dakota, Oregon, Utah, Virginia, West Virginia, Washington, and Wyoming. What has MAC done so far? Well, quite a bit actually. They organized the core group and set up some goals and objectives, met with Congress and key committees over 36 meetings in March of 2015. This included the House Natural Resources Committee and Chairman Bob Bishop and the Armed Services Committee. And they learned that the legislators are actually extremely supportive of miners. Many of them are extremely frustrated by the lack of access and the roadblocks put in place by local, state, and federal agencies, and I should put particular emphasis on the U.S. Forest Service. All agreed that mineral and metal development is a national security issue. This is a photo from one of those first meetings with members of the House Oversight Committee. And another meeting with House Resources Committee Chairman Bob Bishop. This is a meeting with General John F. Kelly from the U.S. Marines at his retirement. Of course, many of you know that General Kelly is now the Chief of Staff for President Trump. In the middle is Buck McKeon. He's a former congressman who we considered actually trying to hire as a lobbyist for some of the legislation we're trying to get passed. The bill would have been approximately $150,000. So we're doing this ourselves. What has MAC done so far? Well, one MAC approved mining district area was released from land designated as wilderness. Several MAC approved mining districts have been taken out of areas of critical environmental concern, also called ACECs, and wildlife management areas. One MAC approved mining district removed from a sue and settle case between the Center for Biological Diversity and BLM, which was resulted in reopening closed lands. Several MAC approved mining districts were allowed to open closed roads. Several MAC approved mining districts stopped new land designations after questioning why they were not consulted. BLM is cooperating with MAC assisted mining districts because of the consistency that exists across these entities. MAC leadership has been requested to come up with several bills to assist in resetting the playing field and to return mining to the priority for public lands. And to this end, MAC has completed an amendment to the National Defense Authorization Act, or NDAA, which will allow MAC-approved mining districts to determine whether or not a closed route should be reopened. MAC has also written a comprehensive 20-page bill which would reset the playing field, and that was scheduled to be introduced later in 2017 or early 2018. MAC returned to Washington, D.C. for a full week in February 2017 and again in March 2017 to provide education to members of Congress and their staffs. I was fortunate enough to attend 2 of their trips and talk to many of the members of Congress. MAC worked with Western Caucus on the proposed bills and met with newly appointed members of the Department of Interior to obtain their approval of our efforts in March 2017. A couple more photos for you. This is when we met with members of the House Committee on Natural Resources and the House Armed Services Committee regarding mining districts and their authority. And we explained our NDAA amendment, which is currently in the markup process, and also our proposed bill. This is a couple photos I'm sneaking in here from a recent trip, and a couple members of MAC had the opportunity to talk with John McCain from Arizona, which is a heavy mining state, and also Don Young of Alaska, who's been trying to help mining districts there for years. So why should you join MAC? Well, MAC has been able to provide solutions and is well on the way to getting your mining rights restored. MAC provides instruction on how to organize your mining districts to reach the goal of federal recognition. MAC provides instruction on how to properly post your mining district and assistance to those members who have regulatory issues or questions. MAC will continue trips to Washington, D.C. to accomplish our goals as long as the funding continues. MAC-assisted mining districts can gain access to previously closed areas. MAC-assisted mining districts should be able to operate under an MOU with BLM, which frees them from many of the overzealous regulations currently in place. And the big one, MAC's goal is to remove many of the local, state, and federal agencies like the U.S. Forest Service from authority over mining because some people within the agencies continue to abuse their authority. And I'm sure many of you have experienced that already. So what can I do? Well, get your mining district organized if it's in disarray. So the first step is to find out the name of the traditional mining district where your claims are located. Track down the original bylaws if at all possible. Attempt to contact other claim holders. You'll need 5 claim holders to make a quorum. Set up a meeting time and place. Publish a public notice. And we here at the Mining Journal are putting in public notices. If you're doing your first mining district, it's $65, which is discounted. If you are already have one that you've attempted to organize or have organized, and you're working on your second one, additional public notices are discounted even more to $35. In addition, many of the folks who organize these meetings are checking LR 2000, which is the computer program set up with BLM, to see if there are other claim holders in the area and attempting to contact them directly. You need to conduct your meeting and elect your officers if the mining district is not currently up to par. Securely post signage at all major entry points to your mining district, and we can provide you of examples of current signage. Attend oversight meetings for the public agencies in your area. This one's kind of big. Currently, the way we have to get a seat at the table is to take an actual seat at the table at these oversight meetings. They're the ones that are currently making decisions in the areas that affect you. You need to encourage other mining districts in your area to get organized. And you need to join MAC so we can show that we have a unified, organized group of mining districts, obtain federal recognition, and so we can send these guys to Washington, D.C. on a more frequent basis to accomplish our goals and get these bills passed. Is there a cost to join MAC? Yes, there is. And I would say first that you are certainly welcome to try and organize your mining district and work through these issues on your own. There are quite a few people who have tried it, although I have yet to hear any one person or group who have been successful in getting their district organized and obtaining a seat at the table and working through some of the regulatory issues without MAC assistance. If you join MAC, the cost for a claim holder is $110 per year. And for that, they will step in and assist you along the way, and including any regulatory issues that might come up that we might be able to address and get resolved. Let's say you have an association claim and there's 4 claim holders on it. Only one person of that group needs to get the needs to pay the $110 fee. That's called a gold membership. The other claim holders can join at the $30 per year rate so that you guys can be covered. And that's also available to non-claim holders or other public land users. So you'll probably receive some paperwork if you're actually at a meeting, and part of that paperwork is to sign up as a gold member or a silver member if you wish, and along with that goes a non-disclosure agreement. The reason we have that out there is because some other groups out there have been trying to copy what MAC is doing, and a lot of people have been frustrated by that effort because they don't have the knowledge or the resources to get you all the way through the process. So we are asking you to sign a non-disclosure agreement. If you have any other additional questions, this is my contact info again. Again, my name is Scott Harn. I'm the editor and publisher of ICMJ's Prospecting and Mining Journal. Our website is www.icmj.com, and you'll see updates in every single issue on what MAC is doing. There's an article titled MAC Update. If you need to reach me by email, my email is editor@icmj.com, and the phone number here is 831-479-1500. Keep in mind that we are on Pacific Standard Time, and we are normally in the office from about 8:30 a.m. till 5 p.m. Monday through Friday. Again, thank you for taking the time to view this presentation.